SJC-13601, Department of Children and Families versus Mother et al.
Attorney Lamanna.
Good morning. May it please the court, my name is Jennifer Lamanna and I represent the appellant, LC Media. We must not allow public institutions to hide behind the privacy rights of individuals in order to evade public scrutiny and critique. In this particular case, and under the specific facts of this case, the lower court judge abused her discretion by failing to properly balance the privacy interests, whatever those may remain for this family, against the public's right to know exactly what happened in a proceeding that led to a child being placed in the custody of her eventual murderer. LC Media came before the lower court using the Uniform Rules of Impoundment standard and alleging that he had good cause to seek release of the specific audio that resulted in the hearing that granted custody to the father in this matter. While it is certainly true that pursuant to its statutory mandate, the Office of the Child Advocate produced a detailed report, it is unquestionable and that report itself was a summary of information that the OCA determined to be relevant and necessary in order to inform the public.
So I agree with you that obviously the most important consideration is trying to figure out what went terribly wrong here. Is there anything that shouldn't be turned over? I mean, are there any residual privacy interests that we have to take into account here, given that? I mean, I'm trying to understand, is there anything that should be impounded in your view?
Well, as you're aware, Justice Kafka, we've had no access whatsoever, so I can't specifically point to a particular statement by counsel during that proceeding that would reveal something that is not already out in the public domain. But as I'm sure the justices are aware, when we brought this motion, we specifically requested from the lower court judge that she exercise the broad discretion that she has to limit, if there is indeed information that the public does not already have, that could be limited when the disclosure is made. So names could be redacted. This is a case that, it goes without saying, has had enormous public exposure, both nationally and internationally.
How does that factor into, I didn't see that as something to be considered in the factors the judge was to consider.
Thank you. I would say it has to be considered because the nature of the public interest is part of the standards under the URIP.
But the nature of the public interest may be, but the quantity of public interest that's already occurred doesn't seem to me to be coterminous with that first factor.
It's certainly not a deciding factor. The fact that you could have an equally serious case that for some reason had not received the same level of press attention, and I think you could still meet all of the other factors.
Okay, so again, why is that then? Why is the quantity of attention relevant?
I think it's less the quantity of attention, but the content of the attention that goes to the privacy interest that Justice Kafka was just questioning.
And by that, do you mean just the subject matter at issue?
Well, the subject matter at issue, but certainly the fact that it appears clear that the underlying statutory scheme for privacy under Chapter 119 is to protect children and families involved in these type of proceedings from the stigma attached to having parents with substance abuse issues, parents who have perhaps performed appalling acts to children, and to protect them from that. In this particular case, the mother herself has freely discussed the substance abuse issues that led her to lose custody of her child. The father, who one would think would have some objections to disclosure, has not objected to disclosure at all. The Department of Children and Families, while they argue strenuously against any sort of waiver of any of the privacy interests, I would respectfully suggest that the design of the statute is not to protect the government agency that's operating.
Do they have any privacy interest, the DCF? I mean, I understand how the mother can have a privacy interest, the father, the children, and maybe even the adopted siblings, but DCF has no privacy interest, right, whatsoever?
I agree with that. I agree with that completely, Justice Kafka. While the department has, in this case and in others I've argued, asserted that the names of the social workers, for example, should be kept private because they're considered under Section 38 of 119, names of the parties. I dispute that. I don't think the names of government actors in the course of their public employment constitute a privacy interest. Certainly, none of these proceedings involve personal facts about the individual social workers.
Well, they do in the sense that the Office for Children finds fault with at least one of it finds fault with DCF. I'm not sure the individuals they find fault with, right? But that report finds fault with DCF, correct?
Yes, that
And
report.
particular individuals of DCF?
Well, the report specifically criticizes counsel for DCF for their lack of legal argument and motions practice in terms of highlighting the department's position in that case. So I suppose technically that's a specific individual at DCF as opposed to the agency as a whole
So
that
they
would be
might
identified.
so they might have some privacy interests, or maybe not. I don't know.
I would certainly hesitate to suggest that a government employee who, by another oversight agency, has been accused of not having performed their duties diligently and appropriately has a privacy interest in protecting public exposure. That's exactly how the public and the press, through that conduit, and the legislature, inform themselves over what reforms are necessary. And I wish to be clear, of course, that this is a case based on these facts, just as MC requires. There must be a factual analysis of this specific case. We are not seeking to reform the entire system. We are seeking to inform the public and the press and the legislature, who has been asked by the OCA report to consider a number of recommendations that would completely alter, for example, the child-directed advocacy model that currently exists for CBCS. We are taking the position that the OCA report, while lengthy.
You are seeking to reform the system, right? That's a big part of your brief is that you feel the investigation here will improve the system and correct the errors that were made, correct? So that we don't do this ever again, or we do whatever humanly possible to avoid doing this again.
There are systemic changes that need to be made. There are seismic shifts that need to happen in the entire juvenile court model. There's no question about that. But this specific case, nobody knows, not the legislature, not anybody outside of the parties themselves and the OCA knows what exactly happened during that hearing that resulted in the court granting custody. And the OCA...
Is that the extent of your request at this point? Because I thought you were requesting, there was an August 2014 temporary custody proceeding, there was a July 15th trial, 2015, December 2018 hearing, where the judge issued the request for an expedited interstate compact on the placement of children report, and then there is the February 2019 review. Which of those four, or all of those four, what are you looking for?
My client initially filed his motion pro se, but was specifically seeking access to the audio for the February 2019 proceeding.
Okay, and that's the limit of your request at this point?
At this point, and again, the judge has given broad discretion to craft an order that shields any potential private information that may still be out there. I don't know what it is. I don't know
But
if
let's
it
go,
exists.
let's go back one. You mean, you're alluding to the judge's broad discretion to craft whatever parameters might be necessary. But if you go back a few dominoes, the judge has discretion to allow your client's request for access or not. And that is subject to an abuse of discretion standard. You started off your argument by saying the public's right to know. So there's really not a right to know here. There is a process by which you can seek to have some access, and the judge, my concern here is you have an abuse of discretion standard. There are certain factors that were weighed in ways that you perhaps disagree with, but does that rise to the level of an abuse of that judge's discretion, or are you asking us to substitute our judgment for the trial judge's judgment?
I am not asking you to substitute your judgment. My suggestion is that the lower court judge did abuse her discretion in two specific ways, in a number of ways that I take issue with, but two that I think are quite specific. First, there is no real analysis in the judge's decision of the actual privacy interest at stake here. There is a passing reference to perhaps the privacy interests of other children that the mother may have. And of course, everybody, while arguing this matter below, kept referencing Section 38 of Chapter 119, which says it shall be unlawful to publish the names of parties to these proceedings. Mothers' subsequent children are not parties to these proceedings, so that would not have protected them. So I found the judge made no specific finding as to what privacy interests remained and how those privacy interests would be affected by disclosure. I believe that was an abuse of her discretion. She was required to do that. I would further add, Justice, that one of the other things the judge was supposed to do was to balance the interests at stake.
This is the second way, the judge?
Yes.
Okay.
Yes. And the second, the judge was supposed to, was required to evaluate the constitutional rights that were at stake here. And I think there cannot be an argument that state-conferred confidentiality via statute trumps the United States Constitution. And the court in this case specifically dismissed any idea.
What constitutional right are you relying on? Because you concede in your brief that you cite a bunch of criminal cases, which is a very different calculus than a civil case here. So what constitutional right are you relying on?
Well, I would first say Richmond News is the first one that comes to mind, of course. Richmond News did involve a criminal case, but as I'm sure Your Honor is aware, throughout the decision-making, there were a number of concurrences. The justices specifically keep going back to the First Amendment and to the 14th Amendment. They do not rely on the Sixth Amendment. And then there's a line of case law from that.
But criminal cases historically are open to the public, whereas these cases are not.
These cases are not historically.
So can you
open.
address for me why that analysis doesn't matter in your estimation?
I am not suggesting that, like criminal cases, every juvenile court case should be open to the public. I'm not asking for a blanket rule that applies in criminal matters.
No, but you're arguing on the constitutional prong of that Rule 11 analysis, and I'm wondering why you're equating access, the right to access to these proceedings, which historically has not been allowed, with those in the criminal proceeding.
So there is an extensive line of cases referring to both civil and criminal matters that discusses the fact that the right to speak implies a right to listen, the right to freedom of the press implies a right to gather information. There is an excellent quote by Justice Stewart in his concurrence in Richmond where he essentially says, we don't expect our public institutions to be fallible, but it's extremely difficult for the public to understand that which it is not allowed to observe. I think particularly taking into account the URIP factors that exist here, there is a constitutional right of the press to access.
How do we measure the community interest prong of MC? It seems to me that this is a case that would, of course, ordinarily be private and not and unsealed. And what makes this case different when you go through the factors is the level of community interest. How is a judge to measure that?
Well, it is certainly within the judge's discretion to do that, and I think that that's part of the balancing
But how?
test. Well, I think that's part of the balancing test that didn't occur here, is to say, so what is the level of community interest? In this case, the level of community interest
Is it if the local
is
paper?
incredibly high. I'm sorry?
Is it if the local paper wants to write about it, or is it, how is this measured? How is it applied?
I think it requires a number of different factors, one of which, for example, is it just the local press? Is it the Lowell Sun reporting on this? Or is it the Washington Post? Is it a number of different media outlets?
It shouldn't matter whether it's the Washington Post or the local newspaper. It's got to be based on the fact that there's been a terrible governmental error here, right? That's what provides the constitutional. This is a different case. It's not an ordinary juvenile case. There's been a terrible error that's resulted in the death of a child, and the public has a right to understand that, right? It's not whether the Washington Post or the Wool paper is interested in it. It's the government's made a big mistake here, and we got to figure out why.
Oh, I agree with that, but I was specifically responding to Justice Gaziano's question, does it matter if it's just the local paper? And I'm saying,
Why should it matter if it's national or local?
if no one knows about it, respectfully, if no one knows about it except for one member of the family who attempts to get public attention, and that person seeks to generate public interest to highlight this horrific act that occurred, that could be sufficient in terms of community interest.
Could I just want to make sure you keep saying that there were things that the trial judge didn't do. So why isn't this more of a case for remand than it is for this court to order access? You keep saying she didn't balance the community interest. She didn't balance the constitutional concerns. All of these different things that you claim the judge did not do. Why isn't this a remand case then?
It could be a remand. That's certainly within your authority to do, to remand and to ask the lower court judge to actually balance the freedom of access that we are alleging is part and parcel of the freedom of the press that is protected under Article 16 and the First Amendment. You could certainly remand it to her to do that, but I think the facts just within the four corners of the judge's decision are also sufficient for you to determine an abuse of discretion was made and a clear error was made and issue a different decision.
I don't know if I follow that, because if I marry Justice Wolahochen, Justice Kafka, and Justice Gaziano's concerned about what's the limiting principle here. Because there are a bunch of these different factors, but you seem to be arguing that the first among equals is how much people want to know. And there are plenty of awful cases where children get hurt or they die in DCF custody. And so what makes this case different, that this is the case that we should say you get access, because this is the one everybody wants to know. But if it just happens to be the next tragic case that no one knows about, that somehow that doesn't factor in and militate in favor of disclosure, but this one does. And this factor is more pronounced and more dense than all of the other factors. How is the judge supposed to do that?
Well, this case is profound. The Office of the Child Advocate specifically found there are certain cases that come before the Office of the Child Advocate in which it is determined the public has a right to know. The case cries out for further explanation. And the OCA in this case took that, assessed it with that same level of seriousness that we are assessing it with, and determined that the public had a right to know. And I wish to be clear, I am in no way implying any bias on the part of the OCA, or that the OCA was in some way trying to shield a government agency. But when the public and the press and the legislature are informed by a single individual's distillation of what they considered to be the important facts, that is the opposite of the right of free access. That is a way to infringe upon the free press, as opposed to a way to ensure that it is robust and given the level of the ability that a public requires in order to be informed and in order to inform their own legislature.
Justice Gaziano, may I ask a question, even
Please.
though the time is? Would you like to briefly address the issue of how your client is an interested party?
Certainly. As I'm sure Your Honor is aware, the definition of interested party under Rule 11 is quite narrow. It simply says a non-party, someone not a party to the lower proceeding who expresses an interest and then explains who they are. So it's not a very high, it's not a clear standard to meet. But my client, as a member of the press, is certainly interested in his role as a member of the press.
Of an interest in a colloquial sense. We're looking here in a legal sense, a legal interest in the case, no?
Rule 11 does not say that. It says...
Do we have any cases that would support your definition of interested party?
Well, I think the press is always considered an interested party when it comes to the workings of government and the workings of our government institutions, that the press has consistently been granted
An interested
access.
entity, but maybe not a party. Right? I mean,
Certainly.
these words have meaning.
Absolutely.
They have legal meaning. I'm trying to see if
Is the
if you fit
definition, though,
into that.
limited to interested party, or is it Is the rule refer to interested party or interested something else? I
The
can't remember.
Rule 11 says an interested person. It says
I thought it was
if I
interested
remember-
non-party.
An interested non-party, that's right. So it doesn't have to be a party. It doesn't have to, it has to be somebody who is able to satisfy the judge they're appearing before by their affidavit and by the facts that they include, that they have an interest. And the interest that was put forward here is by LC Media. We are a journalist. We are deeply invested in exposing concerns and problems with the Massachusetts juvenile court system, and we are seeking access in this specific case, which has already generated a considerable amount of public interest and a considerable amount of contradictory information, and we ask for access for that reason.
Should the definition be different for parties versus non-parties? I mean, it should be different than the test that Justice Gaziano laid out in I forget the name of the case, for parties.
In MC?
Yes.
So it is interesting that Justice Gaziano's opinion in MC specifically refers to the fact that you can use this rule, you can use Rule 7, and it's standard for the Commonwealth or parties. I don't read that as having been to limit the interested non-party from being able to have involvement. But, so perhaps MC needs to be expanded in terms of how the reach of the URIP goes beyond just parties. But
Thank you, counsel.
thank you very much.
Attorney Braithwaite.
Good morning, Your Honors. May it please the Court? I'm Kristen Braithwaite for the Department of Children and Families. Your Honors, there's only one question before you today, and that is whether the lower court abused its discretion in finding that appellant did not meet its burden of showing good cause to pierce the veil of confidentiality that blankets juvenile court proceedings. I'm here today to ask you to affirm the lower court's holding that appellant did not demonstrate good cause under Rule 7 of the Uniform Rules of Impoundment, and that disclosure of audio recordings would violate juvenile court standing order.
If this case doesn't rise to the level where the public has the right to know, I'm just not sure what case would. We've got a little girl who's, been killed because of errors that we've recognized here, but we haven't fully divulged or disclosed. So doesn't this require complete or more disclosure, because the public doesn't trust government to have done this properly unless it can review all the facts or more facts that have been presented so far?
So the answer, I would say, is no, it doesn't rise to the level. I think it
This
does.
one doesn't?
I think it rose to the level in the sense that there is an oversight agency that looks at cases such as this where the public does require.
But the public doesn't have to rely on an executive branch agency to do the vetting. Usually, the public relies on the press.
That's true in cases that do not occur in juvenile court, but in juvenile court,
Right, so what is the continuing privacy interest of anybody who's implicated by the February 2019 hearing, which is, I understand it, the only thing that's at issue?
So first, I want to address the child's continued privacy interest, because I think these privacy interests are at the heart of this case. And I want to be clear that there is no showing that's been made that death extinguishes privacy rights.
Just to be clear, you're applying the MC standard, correct?
I'm applying the MC standard. I think that that certainly identifies the issues for
But
consideration before the court.
Do you concede it applies in this case?
I don't concede it necessarily applies in this case. It's complicated.
not?
MC1 is very clear that this applies only to parties and to the Commonwealth. MC1 also is clear that Rule 11 does apply to juvenile court records. So I don't think clarification has been made about whether this is the test to apply.
Well, should it? What would be the alternative test?
So in this particular set of circumstances, the alternative test.
Well, it can't be a test based on each different case. What is the test for an interested non-party?
So in this particular circumstances, I only mean in the juvenile court context. You have Standing Order 2-09, which discusses the means to access audio recordings in a closed proceeding. They're made available in appellate matters, and then if there is another reason for them, similarly to the Rule 7 procedure, an affidavit is filed, and then the judge has discretion to make a determination either with or without a hearing.
Using what standard?
Right.
They don't, so the order itself,
Well, of course, it doesn't lay it out. The question is only whether the factors that are ordinarily used for lifting of impoundment or impounding should apply in this context where the statute orders that these proceedings are confidential.
I would believe that it does. And the reason I would believe that it does is because it clearly lays out the factors that have been identified as relevant for consideration in determining whether juvenile court records should be unimpounded. With that said, the first test we look to is the nature of the parties in the controversy. And I think that the fact that this is a non-party seeking access is highly relevant to the balancing act of that.
But you're referring to the privacy interest of the child who's been killed. Isn't the child's interest, to the extent we can discern the child's interest, is not in her privacy, but in making sure that this never happens again, what happened to her? Isn't that her interest? I don't understand what her privacy interest is.
Well, there's not been any case law or statute that has extinguished privacy interest at death, and quite the opposite. I would actually direct the panel to the area of attorney-client confidentiality, and in particular, I direct the court to Swidler and Berlin versus United States, wherein the Supreme Court of the United States pointed to the ongoing issues of someone who's been deceased, of reputation, liability, and this is particularly important here, harm to family and loved ones to justify maintaining posthumous confidentiality.
Does that really fit here where the father has been convicted of killing the child? The child is deceased, and the obvious interest is making sure this child hasn't died in vain, that we're not going to do this again, ever. We're going to do everything humanly possible to not make the same mistakes again, right? Isn't that the legitimate interest here?
Well, it is a legitimate interest. I don't know that it is a appellant's legitimate interest, but it's certainly the state's legitimate interest.
But who's if DCF is opposed to allowing this information forward, the father is prepared to have this disclosed. The mother has certain residual privacy interests, which I'm trying to understand. But the person best serving not repeating this seems to be the press.
Not the law around.
Responsible press trying to figure out what happened would seem to be protecting that child's interest, isn't it?
Not in the current statutory or case law framework that governs juvenile court records. I would direct the panel to.
But that creates exceptions, and this seems to be the exceptional case.
Well,
it's not the ordinary case.
The reason appellant suggests this is an exceptional case, and I know this is brought up in amicus briefs as well, is because here the child died. But I would direct.
The child didn't just die. The child was killed after the child was given to the person. The state delivered the child to the person who killed him, right? And that was a father. It's a complicated.
Right, which the state opposed.
The state did oppose.
So you can see the optics of that, right? You delivered, the child was delivered to the very person DCF opposed the child being delivered to, and then this tragedy happened. So why isn't the sunshine sanitation of this be, let's see what happened, open it up?
Because the intimacy, the intimate nature of the details that exist in care and protection cases warrant confidentiality.
But under that rule, we would never allow care and protection proceedings to be open. And I think Justice Kafker's point is well taken that this is one of those extreme cases where maybe the veil of privacy should be pierced in order for the betterment of these placement decisions.
In the event that this court feels that this is one of those cases, I would suggest this is an instance like care and protection of Charlene, where the decision would still need to comply with the law as it stands now, but perhaps the legislature.
But the law as it stands now has, as you've conceded, these 5 factors to be weighed in order to pierce that privacy veil under the statute. And weighing those factors, I can't imagine a case that calls for piercing that more than this one.
Well, the privacy.
Given that the child was killed at the hands of the person with whom the child was placed, that person is asserting no privacy interests. And it's still not clear to me what the mother's residual privacy interests are. It hasn't been articulated in any way. Certainly the media can't say what those interests are, given that they don't have access to the proceedings that they're trying to get to. And I haven't seen that articulated by DCF.
Well, as far as mother's privacy rights, I mean, and I'll allow my brother to speak more on this, but her privacy rights were certainly not extinguished at any point, and she is a party to this matter. It's her
But
intimate detail.
as to the February 2019 hearing, which is, as I understand it, the only thing at issue, what is it about mother's privacy that continues? And maybe that's better directed at counsel for mom.
Well, I'm not sure if I fully follow what you mean about what is.
Well, I'm trying to figure out, one of the things that we need to do is balance the continuing privacy, right? The child has been murdered. The father is not here saying, don't release this February 2019 hearing audio. And the only person who has standing to assert it, as I understand it, under the 5 factors is mom. And so I'm wondering what mom's continuing privacy interest is in the February 2019 hearing.
So mother's continuing privacy interest in the 2019 hearing are that there's information in that hearing that has not been publicly disclosed. And in fact, the OCA report explicitly acknowledges that some information was too private to disclose. And I would,
In that February 2019 hearing?
that February 2019 hearing. And I would direct the panel here to Commonwealth v. Roderick, which stands for the proposition that an individual may lose his or her expectation of privacy in some information and yet retain an expectation of privacy in separate, material, distinct information.
Where does the OCA report say that mom had a continuing some privacy interest in the February 2019 hearing?
The OCA report does not distinguish between where her ongoing privacy interests
Well, see, that
existed.
seems to me problematic for your position, because the 2019 hearing is the only one that's at issue.
But the 2019 hearing was detailed at length procedurally and how it went down. And the OCA report at the outset said, we're revealing the confidential information that we think that the public needs to know in order to know what happened. We are withholding that information that is so intimate as it would be.
Can I ask you, is your position on impoundment absolute, or are there instances where it would give way?
There are instances where it would give way. I mean,
Tell me those instances.
well, it's hard, it's all hypothetical, but for example, in the cases that we have before us, we see people try to use these records for their own criminal defense. Those make a little bit more sense to me. They seem to have more entitlement to the records. I mean, under any analysis, there is no freedom of access to these records. And so then
Just the narrow MC situation?
it's a
in your view?
narrow MC situation, which I would argue is even narrower than MC, because the court in MC, as I know Your Honor is aware, was clear that the test laid out today applies to parties in the Commonwealth. Here we have an uninterested party who has every right to
Okay,
intervene.
so under your absolute rule, there's wiggle room, as you see it, for parties who need the records for criminal defense. Any other instances?
I could certainly imagine that there would be instances, it's so hypothetical, so it's hard to answer, but for example, was there a concern that perhaps something in the February 2019 hearing might give us information about where this particular child was during the time she was presumed missing, which in fact is in Massachusetts?
But isn't that why they want, how do they know if they've not been given that information to look at? We're trusting the Office for Children, and we're asking the public to trust the Office for Children.
I would direct the court to care and protection of Charlene, which is clear that even though there is interest in these records, they are impounded. It does not run afoul of the First Amendment. And here I'd also just.
what are the
Wasn't
facts?
Charlene, the father wanted, on behalf of the public, somehow he wanted to say these records should be public, when in fact he was the cause of Charlene, the child in that case, being in a coma?
Yes, but
So I think that the
overlap-
court was struck by the perversity of that position and questioned even whether the father had standing on behalf of the public. You're not suggesting that LC Media doesn't have standing on behalf of...
I'm not suggesting
Okay.
that LC Media doesn't have standing on behalf
So
of the
how does
public.
Charlene help us here?
But how Charlene helps us here is that it distinguishes that even though there may be a desire to release some information, it cannot be under the statutory scheme. This is a legislative question. Charlene ultimately comes down and says, we think some of this should be made available. It can't be under the current state of the law. And I would argue the same holds
Because
true.
father, when you look at the balancing test in that case, just didn't make a showing.
But I would again remind the panel that we're looking at an abuse of discretion standard. This isn't the case where the judge simply said denied and we don't know why. She looked at the record, she balanced these factors, she made a decision.
Can I ask, was it the same, I'm trying to figure, is the same judge?
Yes.
The custody judge as well as the judge in this decision?
The judge who presided over the February 2019 hearing is no longer on the bench. So it was a sitting judge in the same court who actually did have, at times, she is reflected on the docket when it existed, but she was not the judge who made
It
that
wasn't clear to me, sorry.
Sorry, I just want to make sure. So the judge who did the second decision is not the judge who did the custody decision allowing the child to go to the father?
Those are two different judges.
Two different judges.
Although this judge was involved in expediting the interstate compact report.
This judge may have, she was not the presiding judge of this case, and I don't have the docket to reflect. I can't.
I think the record clearly shows she was the judge in the
So she
earlier
had, I know
decision.
she had involvement in the case, but she was not the one who presided over the February 2019
It
hearing.
was not clear to me, but perhaps it's clear somewhere else, but I didn't see it, that the judge reviewed the audio of the February 2019 hearing. That was not clear to me from the decision. Do you know whether, in fact, the judge did?
I don't know whether, in fact, she did with certainty, but I can say that one line she says in her argument is that there was information that was too intimate to release in the hearing. So that leads me to believe she would have been basing that on having listened to it. With that said, I do not believe she asserts anywhere that she did.
So that feels to me like a hard thing then to know how the balancing was done.
Well, I think she spells out her view of the balancing act, and I agree that people may be able to have different conclusions, but I don't think it rises to the level that no conscientious judge acting intelligently could honestly have reached such a decision. And I would also like to ask the panel to look
Is
to,
that the old abuse of discretion standard you're reading from, or the new one?
that's from Care and Protection of Georgette. It's been modified a little bit, but another one we could look at that
We'll look at LL, which is our abuse of discretion standard.
fair, but even still, I really don't think you could find this judge did not meet that standard. She held a hearing, she ruled on each factor, she weighed them. And again, I would also, I know it is not binding, but I would also like to just direct the panel to its adoption of GEMMA. It is unbinding, it's a Rule 128 unpublished opinion, but it's an instance where a foster parent sought records, and the fact that the foster parent was not a party was part of the balancing act. They still did a Rule 7 analysis, but found that it was relevant.
Can I ask you logistically, I'm sorry, as a logistic matter, assume for a moment, and I have no reason to believe this is true, that this panel believes that the case should be remanded for a rebalancing of the 5 factors and actual listening to the audio of the February 2019 hearing in confirmation of that fact. Is there a way to redact things from the hearing? Is that possible, given the use that this journalist expects to make of the transcript? The reason I ask is because it seems like an MC there was allowance for access for, I think it was the defendant in the Commonwealth in the criminal case, to certain records, but the records still belonged to the juvenile court and were to be returned in some sort of fashion afterwards. How does that work in this context where it's the media?
Well, it doesn't. I mean, one of the things that comes up in MC and also in various contexts is that the whole purpose of allowing these records is still meant to be in protection of public disclosure. So even when these requests have been granted, there's been...
I thought that's not what, I thought she raised that as a possibility, that once she reviews it, that they're open to some discussion about limitations, the way Justice Wendlandt just phrased it. I thought that's part of their request.
Well, it was something that was suggested later, but I think even still what they're seeking to use would be for public disclosure. And so the distinction I'm making is simply that when they reached a compromise in MC, it was also held that there would still be limitations put on how it could be used to ensure it did not enter the public forum. Whereas here it's being sought specifically for public disclosure, which is in direct contravention of the policy surrounding this, which is why the lower court judge identified this as being a question for the legislature and not for the court, because we have law that answers these questions. So I think what's challenging is it might be one of those questions where we want it to say something different. But as the law stands right now, the privacy interests are the most compelling interests in this case.
Thank you. Any further questions? Thank you, counsel.
Thank you, Your Honors.
May it please the court, good morning. My name is Andrew Hoffman. I represent the appellee mother in this case. She opposes the petitioner's request for access to information and asks that this court affirm the lower court's decision to deny the petitioner's motion. I'm sensing that you have been waiting to ask me what remaining privacy interests the mother has. I do want to address that. If I could quickly address a couple of other issues that have been raised here, because I do think they're extremely important. The first is the last question, it was just raised by Justice Wendlandt and then touched on by Justice Kafker. The petitioner did propose a remedial idea. Actually, he had three ideas. One and two were kind of similar, which is basically go through and ferret out, select out just the information pertaining to the judge's reasoning and leave out all of the mother's privacy interests. The last suggestion was that the parties get a copy of the transcript ahead of time and get to go through and redact that. And my client's position is that those would not work here. One, it's a major assumption for the first two of those proposals that this information is can be easily segregated, that somehow during the court proceeding that they touched on only mother's privacy interests at one point, and then at a separate time, only the judge's reasoning for making her decision. When in reality, as we know how things go in court, it's much more likely that those pieces of information, those points, were most likely jumbled. So it's unlikely that those would be easily segregated.
So mother's position is that this has to be disclosed totally or not at all?
Well, so not necessarily. What I was going to say is for the third one is, in this case, this is a pretty, according to care and protection cases, which I'm sure this court has seen, this is a pretty thin evidentiary record. This is not, meaning this motion was filed, these proceedings were based on this motion. But as this court probably also knows, in some of these cases, the record can be voluminous. And it would work an unreasonable burden on a parent to have to go through potentially thousands of pages of a transcript and identify those portions which are privacy interests and objectionable versus those which are not. That would be a shifting of the burden of proof, which is impermissible to the parent to do that.
I'm not sure I understand why it would be so difficult. Again, I understand also that there's some disagreement about what has been made public by the mother and what hasn't been. But why is it not possible to go through the transcript and identify private material of the mother that she hasn't already disclosed? If she's been on TV or she's been talking about her substance abuse or whatever her problems were before, why couldn't you do that?
Right, which So a kind of a two-part answer. One, as I said, in this case, it may have been possible to do that. The test, as we've already discussed this morning,
So
is-
wouldn't that solve your client's interest in that, if you just go through the transcript and redact out mom's personal information?
It could potentially. I was thinking about a, frankly, polite way of responding to this question I knew that was coming, which is, again, to the shifting of the burden, that the mother shouldn't have to, the way I would phrase it, shouldn't have to disclose her privacy interests to then protect her privacy interests. In other words, it's a perversion of logic and shifting the burden for her to speak up and identify affirmatively what her privacy interests are when those are the exact interests that she is trying to protect.
Wouldn't that come out naturally in the hearing, though? Her issues or the things that give rise to privacy interests would be the natural part of these proceedings, correct?
Yes, but then that would be brought out to the parties, but we're talking about here a non-party who's seeking access to that. So that's.
But she wasn't even a potential, right? The mother wasn't seeking custody, right? She wasn't seeking custody. Her problems seem to be peripheral to the issues that are being dealt with by the judge, which is whether to give the child to the father or to keep the child with DCF. So, I mean, I'm not even sure how interested they're going to be in the mother's information as long as they can figure out why did the child go to the father given his criminal record.
Right. I agree with the first part of your statement, not the second part.
Go ahead.
So you're correct. She, at that point in the process, earlier in the case, yes, they had been seeking reunification to mother. She had been seeking reunification. In fact, the child had been returned to her and then removed a couple times. At that point in the process, no. They were only looking at the father. But what I don't agree to is the use of your term peripheral. The whole point of 11938 for privacy interests.
Fair point.
Yeah,
But
so-
that's not most likely to be what the focus of the press is, which is why did it go to the father and why did the system allow it to go to the father who ends up killing the child? So I just don't see why they can't deal with your interest the way Justice Wendland talked about, which is dealing with this once the material is disclosed and then working out something that protects the mother's interests.
Right, and so that's exactly, so the response is, and this is what the lower court judge touched on in her ruling, is you're probably correct. I mean, we don't know exactly what the press would do with mother's privacy interests, presuming even that that's not really their
No, but if
interest.
it was redacted out, they would have no choice but to do nothing with it.
Yeah, they
So
wouldn't
that
have
would
it.
be
They wouldn't
fine for
have it.
your client,
They wouldn't
right?
have it.
Or they'd have to agree to a confidentiality of
That might be
something.
possible, but to
Right.
try and respond to your question, we don't know what the press would do with that, and that was the judge's exact point in her ruling, is once it's out, there's no meaningful remedy.
Well, there's contempt. I mean, that, to me, that seemed,
That doesn't, I'm sorry, go ahead.
well, it may not satisfy you, but it's certainly what the judge can do to enforce an order.
That is certainly an option available to her. It wouldn't satisfy protection of the privacy interest, and that was a basis for her decision, and that doesn't rise to the level of abuse of discretion here.
Would redaction satisfy privacy interests?
If it could be accomplished in this case.
Well, it seems like you're conceding that it could, because it's just the February 2019.
I'm conceding it's possible. We don't have enough information to know, and it was within the judge's
So
discretion.
shouldn't we
to decide.
remand it to find out, as
That
opposed
would-
to trying to guess?
That would be one option. And if I could, I realize I'm over time, but quickly, the one other point I want, because several of you have raised it, is the standard. A strict reading of MC, as was noted by counsel earlier, limits the test under 7B to just parties in the
Well,
state.
it
Well,
wasn't,
it
it wasn't
doesn't-
raised
yeah, it
in
was-
MC. That wasn't an issue in MC.
Right, the question
I
for this
understand. No.
case is, do we apply that same standard for a non-party?
Right, so what I was going to say is this, I think a strict reading would say 7B doesn't apply, and you're just left with standing order 2-09.
What would be your alternative test to the one articulated in MC?
I don't, what I was going to say is this, I think it's eminently reasonable to have a balancing analysis like 7B, and if MC needs, if this court wants to add on to MC 1 and 2 to say we want to clarify that this balancing analysis does apply to non-parties, I think that's eminently reasonable, and that's what I would propose. It does seem like there should be some balancing analysis rather than just strict no access under 209.